officers are here, it would be taken care of. It's not concerning this. Everyone has a right to appear before your lordships. It can never be by way of a retribution. There is something else, my lord,
Mr. Solicitor, the close proximity between the arguments and the order.
The timing is, my lord, definitely not proper. I bow down. I bow down. Timing is not proper. No argument on that.
Timing and reference to this aspect, if it is there in the letter. I don't know. I have not seen the letter. I do not know. But if the reference to his appearance here is there, then there is a little problem. What happens to the so much freedoms in part?
Yes, yes. Absolutely.
Yes, Mr. Solicitor.
Lord, on Friday, on Thursday, Lord, your lordships, my lord, desired what happened to other assimilation of other states. Lord, during the weekend, my lord, we have undertaken that exercise. The documents were available in the National Archives. And the officials of the Home Ministry went in National Archives. They studied everything. And we have prepared a 2-page note for that, my lord. If your lordship allows, I can, my lord, immediately share it with others, my lord. And
what you can do, it since it was in response to a question of the court, you can just ask the nodal council to make it a part of your submissions as an annexure, so it won't get misplaced.
Correct.
Make sure and circulate to the other side as well.
My lord, right now, would your lordships like to?
Yes, yes, we can see it right away, no problem.
I'll just, my lord, kindly allow me to send a mail. It is sent.
Camilla?
It won't take more than, it is sent. And the other side.
Yeah, our whole line, there was no.
It's in fact a 1-page note, my lord, not even. Rest is, my lord, list of states. So we need not read the list. The figures would matter, my lord, not the names.
In the meantime, if you have it for my colleagues on the...
Lord, can I be permitted to circulate?
Yes, no difficulty. We'll see it. Because it'll take a few minutes to otherwise come on the email.
One more. One more. One, I have already said this is from National Archives, coupled with, my lord, facts stated in the white paper. I'm sorry, my lord, my lords.
Now there on all the members of the bar will also get it on your screens in front of you actually.
It is now received. It is received.
It's now on the screens for everybody, yes.
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 First is, my lord, we have said that this is combination of our research in the National Archives and white paper. Second, at the outset, it is necessary to clarify that the process of integration of princely states with dominion of India and or Union of India was not a linear process. The merger agreements and instruments of accession, along with proclamations, did not operate in a step-by-step manner for every state. They represented various means of integration of princely states with the country. The signing of either of instrument of accession or revised instrument of accession or merger agreement or even a proclamation only, like Hyderabad state, is sufficient for integration with Union of India. Therefore, the list of princely states which fall under merger agreements are separate from the list of princely states which are covered with instruments of accession or revised instruments of accession. Therefore, broadly, there are two heads, princely states falling under merger agreements and princely states falling under instruments of accession followed by proclamation. Under the first head, princely states falling under merger agreements, the princely states were of two kinds. A, princely states with merge with the existing Indian provinces, British controlled provinces. And second, princely state with merge with states as centrally administered areas. Some of the princely states desired that we should be directly governed. Some of them were strategically so located that
they became the chief commissioners.
Chief commissioners provinces, your lordship, sir. The next category of princely states, this is important. Table C are the ones covered by the instrument of accession, revised instruments of accession, followed by proclamations. The distinction between the two is of terminology and not of step-by-step linear process, as a large number of states directly sign revised instrument of accession without signing the pro forma instrument of accession before that. Therefore, the same is being clubbed and expressed as table C. Princely states covered by instrument of accession or revised instrument of accession and proclamation accepting Indian Constitution. It may be noted to the limited position emanating from the National Archives and White Paper that these princely states did not sign any merger agreement. Lord, then your lordships would come to the next page. Lord, 1 to page 1 is, my lord, 1 to 32, then 33 to 65, then, my lord, 66 to 77. The lordships have, my lord? The rest is not available. Lord, please see, my lord, the states from Balasinore to Surgana were a part of one group which had a total of 144 states. They formed their own group. Therefore, my lord, they are 77 to 144. Then, my lord, total comes to 204. So we have started with 205. It goes up to 216. Then provincially merged Khasi states. Khasi states were essentially in the northeast, and, my lord, they are 241. Total, my lord, are 241. Then, if your lordship turns the page, this is table B. Princely states which were merged with states as centrally administered areas. Then, my lord, we have started with 242. It goes up to 302. We need not, my lord, read the names. These were, my lord, the states which were centrally notified areas. Now, my lords, may kindly come to para 7 at the foot. It is to be noted that the above agreements were signed by the Secretary, Department of States, Government of India. On signing of these merger agreements, orders under the relevant provisions of the Government of India Act were issued, giving legal force to these agreements. Then, my lord, table C. Princely states covered by instrument of accession or revised instrument of accession and proclamation accepting Indian Constitution, no merger agreements. There were several states which did not sign merger agreements, my lord, which we have started from 303, taking, my lord, the list from 302 on the earlier para, and it goes on till 580. So it is 555 plus 24 because Khasi states are separately dealt with even in the white paper. Therefore, my lord, this is the total figure which became a part of Union of India when Article 1 came into force. And, my lord, we have given the disclaimer that, of course, this is based on National Archives and the white paper. But, my lord, as a matter of interest, my lord, the National Archives, my lord, the officers, my lord, the Joint Secretary and others who went, well, it's worth visiting. It's very well maintained National Archives. My lord, in some of the documents, you need to maintain a particular temperature so that the document is not destroyed. My lord, every care is taken since beginning. As an interest also, your lordships may not consider once visiting it, not for this matter, but there are several historical documents, several films. Films, not, my lord, as we understand, my lord. That some of the documents are filmed and they are preserved. some of the speeches of our national leaders, my lord, whichever could be videographed in those days, are very well preserved. There are several maps and many, my lord, matters of historical interest. But the beauty is that since the beginning of the country, it has been preserved well.
Yes.
My lord, I was at page 47, my lord. And whatever is irrelevant, your lordships may, my lord, take it from me. Again, I have, my lord, diluted, and I will not take much time, my lord. Whatever may be relevant to be put here as a completion of chronology, I have put it, I will not read it, my lord. Page 47, my lord. Now, my lord, this is after India attains independence and the constitution is adopted. My lord, constitution is adopted, my lord, we are aware, my lord, 26th of January, 49. 26th November, 49. I'll just check up, my lord. Our impression is subject to verification. Article 1 came on that very day. From the beginning, Article 1 is there, subject to, my lord, verification. Lord, page 47, CO 10.
Yes.
I'll just orally point out what it contained two aspects. My lords are aware, my lord, Article 371A, which provided that first take the list of 3 entries which the instrument of accession maintained, that is defense, communication, etc. And the president was to find out which are the corresponding entries in the union list. Because defense can have 5 corresponding entries, communication can have wireless, telephone, etc. 5. So, my lord, first act, my lord, which I have mentioned is that, my lord, with which your lordships may directly not be concerned, just by way of, my lord, an example that the Honorable President, by this first CO, identified the entries. That these entries would fall within those 3 broad subjects which the ruler has given under the instrument of accession. Then it is exercise of powers under 371D and applying these provisions of the Constitution of India. Your lordships would find I'm not reading union, relations between union and states, but all were applied with modifications. As Article 370 or itself, Lord, points out, for example, amendment of the Constitution. 368 was applied, but with a provision in sub-article 6 that any amendment made in the Indian Constitution would not ipso facto apply to the Jammu and Kashmir.
You follow the Article 370 route.
Unless applied through Article 370. So, my lord, in that fashion, Lord, the second part of this CO 10 is,
the first part was with consultation, the second part was with concurrence.
With my lord, concurrence. Concurrence, my lord, consultation is only qua.
As far as 368 is concerned, the constitution can be amended in terms of that article by the parliament and so forth. Now, as far as proviso to 368, it says that the legislative assembly can then adopt, or with concurrence, then it will apply over. Whereas D requires concurrence. Concurrence probably will be prior concurrence.
That would be so.
Because when we are talking about constitution as it exists, 371D refers to the constitution as it was originally enacted.
Okay.
368 refers to the amendments to thereafter. So there's a slight difference between the two.
Yes. So whatever amendment is made in any part of the Constitution would not apply unless it is so applied either fully or with modification and exception under 371D route.
It will be 371D route or 368 route?
No, it would be 371. For that.
368 is not in this red book, no?
No, it is now deleted.
No, but the red book has a lot of other things, but some of the others not there.
But would your lordships like to see, my lord, the original the CO? My lord, that your lordships would find
It
at
should be here actually. All the
volume
commands are
3.
here. होना तो चाहिए, देख लो. उसमें.
Manoj, let us take a hypothetical illustration, Manoj. Just Manoj,
It's just a matter of logics, that's all.
yes, Manoj, only 2 minutes, Manoj. The concerned amendment, Manoj, in this CO is at page 4 and 9, 4 to 9, in volume 3,
Volume 3, right?
CCD. Please come to Manoj, page 8, Manoj. The directly, Manoj, page 8. And I'll give one illustration only, Manoj, at the foot, Manoj. Your lordships have, Manoj, 360, Manoj, part 12, part Roman 12. I'm sorry, part Roman 20. My apologies. Part Roman 20. Manoj.
Which page are you?
Page 8, volume
page
3, the document volume 3, PDF page 8. This is, Manoj, the concerned CO 10.
Unless applied by order of the president and a clause.
Provided, I'm sorry. Yes, my
we
Lord
got it.
Justice Khanna gets me.
Page
Provided the proviso, Article 368 shall apply, subject to the additional proviso, provided further that no such amendment shall have
Just
effect.
1 second. One.
This talks back to article.
Yes, but I'll just give an illustration.
It says.
Yes,
371.
my Lord, just to illustrate, my Lord, for example, Constitution of India amended and inserted Article 21A, right to education, free education, etc. It never applied to Jammu and Kashmir till 2019 because this route was never followed.
Likewise, as you said, the preamble amendment of 1976
Was
what is it?
applied with modifications, etc.
So the secularism and socialism amendment was never adopted in the case of
Yes.
Jammu.
Yes, even integrity word is not there. That was also not applied.
We can skip this now. We can go ahead.
Yes. Lord, Lord, this is contemporaneous. Your Lordship would find the date. It is 26th of January, 1950. So contemporaneous, nothing, my Lord, much turns on that. Your Lordship may, my Lord, directly come to page 49.
Page 49 of the same volume.
Of my written submission. I'm sorry, my written submissions. Lord, it is respondent conjoint written submissions.
Yes.
Written submission, volume 3. My Lord. Lord, 1st May, your Lordship gets the date. My Lord, the Chief Justice gets it. 1st May 1951, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected constituent assembly to draft a constitution for the state of Jammu and Kashmir. Please don't read the note, my Lord. I'll orally point out what it says. Lord, when I take your Lordships to the position of Jammu Kashmir Assembly vis-a-vis our constitution, my Lord, the Constitution of India and the Constituent Assembly of India, Lord, I read that proclamation just to show that it was intended to be subservient to and subordinate to the Constitution of India. But right now, this is a date that the
Mr. Solicitor, you may deal with this, what I'm suggesting, but I'll forget it. So, I was reading a list of dates in the morning, the thought struck me.
Yes.
At one level, you may be right, or subject, of course, to what we have to consider on the rejoinder, that your argument is that the Constitution for the Republic of India is really a document which lies on a higher platform than, say, the Constitution of the state of Jammu and Kashmir. That J&K Constitution, according to you, is subordinate to the Union Constitution. That's one aspect. The second aspect which you have tried to make out in your note, which we may elaborate it upon it later, which is your contention that, look, the Constituent Assembly of J&K was in the nature of a legislative assembly and not a constituent assembly. That, strictly speaking, that there may be a problem for two reasons. That's not how Article 372, bracket 2 refers to it. It refers to it as a constituent assembly of the state.
Correct.
But more important, once Article 238 made certain provisions of the Constitution inapplicable to the Part 3 states, and particularly the state of Jammu and Kashmir, including executive, legislature, judiciary, which would be brought into force by the Constituent Assembly framing a constitution for the state of Jammu and Kashmir, then it may be very difficult to call it a purely just a legislative assembly. That is an aspect which you may want to deal with. You may deal with it in just one
Because that
sentence,
is
and
a
then maybe
separate segment, my lord, of my
then
subject.
we will deal with it at that
I-
point,
I'm
on the
obliged.
list of dates.
I am obliged. My lord, rest of the 3 dates your lordships can, my lord, ignore. Kindly come to page, no, not ignore, my lord, skip. Sorry, my lord.
And we have read Sheikh Abdullah's address was read out to us by the other side. So we
I'm not
need not
reading, my lord, any address now. I'm just on the chronology,
Yes,
and
yes.
chronology which is relevant right now.
Absolutely,
Which
you can
would,
go.
rest
Yes, yes.
is, my lord, for completion, but may not, my lord, invest your lordship's time. Then, my lord, Constituent Assembly is created. Now, my lord, comes CO 39, that is 1952 CO. Lord, please see, under Article 371, Lord, these are all, appears to be, my lord, powers under 371D, but all COs mention it as 371. Maybe making a little broad source of power. Of the Constitution of India, in following consultation with the government of Jammu and Kashmir, the President issued the so-and-so order 1952, modifying Article 54 and 55 of the Constitution insofar as it applied to the state of Jammu and Kashmir. By this CO, for the first time, President recognized the Constituent Assembly as the Legislative Assembly for the purpose of election of the President of India. Your Lordships would, my lord, note, when Constituent Assembly of Jammu and Kashmir was formed, obviously there was no Legislative Assembly because that was yet to be a part of the Constitution to be framed. So as to ensure that they do not lose their representation in election of the President, Lord, this CO was issued that you will be treated as Legislative Assembly also. Lord, your Lordships would find at the end of this chronology, 370 has been applied in kind of a floating way. Whenever, my lord, it is required to use the word interchangeably, it is logically so used. And whenever any word has become OTOs, it is replaced by its successor. Lord, this
At that point, there was no legislative assembly at all.
at all, correct. I say
Therefore, they had to make this CO
correct.
to read that instead of the word legislative assembly shall also include a reference to constituent assembly. Because at that point, there was no legislative assembly.
My lord, exactly that is where, my lord, I would respectfully drive it. When there is no legislative assembly, constituent assembly, the president has said that now it would be treated as legislative assembly. But that I'll come little later. Lord, it has been used, my lord, kindly see there are two, my lord, prominent features in COs which comes up.
Yes.
A, it has been used in a floating way, some words used interchangeably. And second, and most important for my purpose, whenever a word in Article 370 becomes OTOs for that post not being in existence, that body not being in existence, it is immediately replaced by its successor. Sadr Riyasat is replaced by governor, etc. Now, my lord, your lordships may come to the next date, 20th of June, 5th.